company walked into your offices and said, look, we're working on something, we think it can accomplish A, B, and C in area X, where right now there is no one else working. What's the best thing I can do in terms of finding a way where I can get this thing manufactured at scale? Because I don't have the resources to do that. What's the best advice someone should give in light of existing law on the subject based on the decision in the case at hand?
I think maybe both of us can answer, and maybe I'll jump in with a few ideas. So, I think the first thing is that you have to always think about making sure that you're going to file this application on this idea early. So you always have to have that in the back of your mind. And another thing I think we can think about from the medicines company case, that certain types of contract manufacturing, or even if you hire somebody to make a prototype. So that type of activity can be okay, but again, we have to make sure we have certain safeguards there as well. And I think we've discussed a couple of them, and there's probably not a very quick answer for this, but if you're going to enter into some type of agreement with somebody to make a prototype, you want to make sure that the agreement is confidential, right? So you have a confidentiality provision. And you always want to be keeping in the back of your mind that you are still the owner. So again, you want to retain title, that this is your invention. You don't have the facilities, but you need to go to, this other person who is going to help you manufacture the prototype, but it's, title is going to stay with you. It's your invention. And you're just hiring him for the service of making it. And again, you want to make sure this is confidential. And after Helsinn, we certainly do not want, this information to go into the public domain. So you want to make sure that for the time being, that you keep it confidential. And I think, like Nate was always saying, then you want to make sure you file your application on this idea early, and sort of, just make sure that there's no question. So you want to get that, you want to get either, a patent application on file right away. And I think that's probably the most important bit of advice. And then as you move forward, you still want to do the manufacturing, and you have an agreement, and you talk to your lawyer, and you make sure that your agreement is in line with what we know with medicines company with respect to building these prototypes and contract manufacturing. And I think that would be generally what I would say.
Yeah, this is Nate again. I generally agree. I think, as we sort of mentioned, there's a lot of ways that you can structure agreements to try and do everything you can to avoid these bars. But at the end of the day, I think anytime you're doing some sort of commercial work, there is going to be some risk. And so I think the way this comes up most of the time would be where you want to start where you want to continue to develop some facts or get some study results that you can put in your patent application in order to have written description support for whatever claims you're hoping to eventually come out with. And so the big thing I would say is, when you're kind of doing these negotiations with a third-party vendor of some sort, note when you would say that you made your first offer, or when they made their first offer to you, and try and get as much of the data as you need within a year after that date, and get that provisional on file at that point. That's the big thing I would say, is there will always be, I think, some risks no matter how creative you are. And so if you can get the provisional on file within a year of when you start these negotiations, I think that's your best bet.